Welcome to EI Legal's video on the hierarchy of Australian employment instruments. I am Hannah Mills, a solicitor here at EI Legal. Many people assume that an employment contract is king and that whatever terms are contained within an employment contract will automatically override any other entitlements. Whilst in some ways this is true, it is also important to understand how contracts fit into the hierarchy and how the different employment instruments operate together under Australian law. At the very bottom of the pyramid, and most important, are the 10 National Employment Standards, also known as the NES, which essentially apply to all employees. The National Employment Standards include entitlements such as leave, notice of termination, working hours, the right to request flexible working arrangements, and redundancy pay. An employer or an employee cannot contract out of these entitlements. So an employee cannot say that they don't want a certain entitlement, and similarly, an employer cannot refuse to offer an employee one of the NES entitlements. Any conditions in an award, agreement or contract which provide for conditions which are less favourable than those set out in the National Employment Standards will be unenforceable and could result in fines for an employer and claims for back pay. All employment relationships are also subject to many different types of legislation, including long service leave legislation, occupational health and safety legislation, and workers' compensation legislation. As is the case with the National Employment Standards, employers and employees cannot agree to contract out of these laws, and they will apply to everyone, regardless of what an award, agreement, or contract says. Modern awards. So above the NES in our pyramid are modern awards and agreements. Modern awards are a type of legal instrument that contain minimum terms and conditions for employees employed in certain industries and in certain occupations. Modern awards typically include parameters around the hours of work, minimum wages, overtime, penalties, consultation, and meal breaks. Whilst awards have traditionally been common in a number of industries, such as the manufacturing, hospitality, clerical, and fast food industries, the introduction of modern awards on the 1st of January 2010 means that some employees in professional industries, such as the legal services and banking, finance and insurance industries, are now also award-covered employees. Any condition in a modern award, which is more generous than the NES, will prevail over the NES entitlement, so that the employee receives the more beneficial entitlement. Agreements. An employee's employment could also be covered by an individual or collective agreement. The term individual agreement includes Australian Workplace Agreements, AWAs, or an individual transitional employee agreement, also known as ITAs. Although employers and employees can no longer make these kind of agreements under the Fair Work Act, any individual agreements that are already in place may continue to operate. Essentially, a collective agreement is an agreement made between an employer and a distinct group or all of their employees at the enterprise level. In the past, these have been known as certified agreements, employee collective agreements, or union collective agreements, but under the Fair Work Act, they're now called enterprise agreements. There are some correlations between awards and agreements, and importantly, once an enterprise agreement comes into operation, it replaces any applicable modern award. As discussed, the reason that the employment contract is at the top of the pyramid is not because it's king, but actually because it must meet at least the minimums set out in the NES and any applicable award or agreement. The next video in our series explains what a common law contract is and when it's used. For more information on this topic, please visit our website, or if you have any questions, feel free to contact us on the details provided. Thank you for watching.